Buenos días, buenas tardes, y buenas noches a todos y todas. Good morning, good afternoon, good evening to everyone. We welcome you to the 2023 Rule of Law Webathon. It's a week-long program organized by the American Bar Association International Law Section, IABA, the International Association of Young Lawyers, the Human Rights Committee, the Inter-American Bar Association, what we have the honor to represent, and UIA, the Rule of Law Institute. The program today, this panel on environment, conflicts, and climate change, resilient rule of law, presented by the Inter-American Bar Association, we'll discuss issues regarding environmental degradation and the fact that the degradation and competition over scarce natural resources can directly cause and exacerbate the root causes of social conflicts and wars, driving greater environmental damage and undermining prospects for peace. I mean, in the same way that, environmental competition over environmental resources creates conflicts, also conflicts and wars creates a lot of damage in terms of human, impact, but also the environment that in turns will affect humans. And these topics nowadays, we know, have to be seen and studied and understand and addressed in a very holistic, with a very holistic approach. Otherwise, really, we are basically targeting part of the problem and not the whole problem. These forces can also threaten our societal infrastructures and violate basic human rights, such as the right to clean air and water, adequate nutritious food, a healthy environment, and a stable global climate. This panel will reflect on how the rule of law is an essential component of good environmental governance. Our panelists, which is an excellent, diverse international panel, will discuss human rights and environmental due diligence, access to effective remedies, and conflict prevention and peace building. We are one of 9 different panels being offered during this 2023 Webathon week, dedicated to explore, analyze, and present perspective on this year's theme, which is upholding the rule of law in challenging times. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense. The rule of law is not merely the stock and trade of lawyers. It is our core value. The universal commitment of the world's lawyers to the rule of law inspired us to join forces and launch this 3rd event, persisting in the effort. Is the 3rd event of its kind, this Webathon. It used to be actually a 24-hour, all day around the clock and around the world, but this time it's going to be a week-long Webathon, and we are proud to be part of it. We'd like to welcome all of the attendees, and especially, to our panelists. And I'd like to thank and welcome also Lisette Robleto de Howard, who's co-chairing this, has been co-chair with us, organizing this another panel on human trafficking that we'll have on Wednesday. As representing the IABA as senior member and also as member of ILAC, the International Legal Assistance Consortium, and an attorney in the UK. So without more, I would like to leave the floor to Lisette, without first thanking, Sophia, Tomas, Danielle, and Julian for joining us, and she will do, the presentations in due course. Thank you very much.
Buenos días, buenas tardes, buenas noches, good morning, good afternoon, good evening to everybody across the globe. My name is Lisette Roberto de Howard, and I'm really grateful to Lourdes for that kind of introduction. I'm also very humbled to be sharing the panel with this amazing array of speakers and panelists. The webinar or the webathon will consist of a panel discussion, but we will kick off by a keynote speech held by the Assistant Director General for Social and Human Sciences at UNESCO, Gabriela Ramos. She will be speaking to us about in a recorded message, and her, the main message will be focusing on the role of AI, artificial intelligence, on human rights, the environment, and climate change. Gabriela has among her agenda the achievement of social inclusion and gender equality, advancing youth development, promoting values through sport, anti-racism, anti-discriminatory agenda, and ethics of artificial intelligence. Prior to her position at UNESCO, she served as the Chief of Staff and Sherpa to the G20, G7, and APEC in the OECD, contributing to the global agenda, as well as leading the OECD's new approaches to economic challenges, inclusive growth initiative, gender inclusive growth platform, bringing together 40 major multinational companies committed to reducing inequalities. Previously, she was director of the OECD office in Mexico and Latin America, and a member of the Mexican Foreign Service. Lourdes, are we ready with the message?
Lisa, could you continue with introducing the rest of the panelists, and then it would be finally, set up? Thank you.
So while the perennial technical difficulties are resolved, thank you for your patience. I will be introducing our panelists as well. So firstly, we will have Maria Sofia Sagues. She will be speaking to us about the structural discrimination relating to environment and conflict. Maria is a doctor in law from the Argentine Catholic University. She also has a master in law from Georgetown University. She's director of the Diploma in Latin American Constitutional Law at the Universidad Austral in Argentina. She's also the author of 2 books and has co-authored another 2. She's the author of more than 100 chapters in collected works and articles in periodicals. She's the legal secretary of the Corte Suprema de Justicia de la Nación in Argentina. Welcome, Sofia. We will also have our second panelist, Daniel Sumalavia. He will be talking to us about environmental protection and environmental protection. He is a Peruvian lawyer, graduated from the Pontificia Universidad Católica del Perú. He has a master in international legal studies with a specialization in international environmental law from the American University. Daniel has more than 15 years of experience working in diverse organizations as a legal advisor and consultant on social environmental issues, from international organizations such as the World Bank, the Organization of American States, and the Inter-American Task Force for Women's Leadership, as well as experience in working regionally in global NGOs and the Peruvian government. Our third panelist will be Julian Newman. The title of his intervention will be Costing the Earth, Tackling Environmental Crime. Julian is a campaigns director at the London-based NGO Environmental Investigation Agency and has worked for the EIA since 1997. The EIA was established in 1984 to investigate, expose, and campaign against environmental crimes. He joined the organization as an investigator, and during his time at the EIA, he has carried out field investigation into a range of environmental crimes, including illegal logging, smuggling of ozone-depleting chemicals, and waste, as well as illicit trading ivory and tiger parts. He has also been involved in training NGOs in Indonesia, Myanmar, and Tanzania on field documentation skills. He's currently, as I said at the beginning, a campaigns director, a position he has held since 2008. Before joining EIA, Julian worked as a journalist. Finally, we will have Thomas Andrew O'Keefe, who is the president of Mercosur Consulting Group and teaches at Stanford University. He's currently the chief of party for USAID's Caribbean Business Enabling Environment Reform project based in Barbados. A dual US-Chilean national, he was an exchange student at Tel Aviv University and holds degrees from Columbia University, Villanova University School of Law, and the University of Oxford. In 1986, he worked for the legal departments of the Chilean Human Rights Commission and the Vicaría de la Solidaridad, the Human Rights Office of the in Santiago. He chaired the Western Hemisphere Areas Program at the US Department's Foreign Service Institute between 2011 and 2016. He has an illustrious career and he has written extensively as well. So as you can see, we have a fantastic group of panelists. They are going to be presenting for 15 to 20 minutes. That will be followed by questions and answers from the floor. And I will, at the end, attempt to summarize some of the key findings from our panelists. Lourdes, are we ready?
Hello. Sorry, apologies for this technical difficulty, but the video we were having trouble downloading, but it's basically there. I just wanted to take advantage of that time to also, I thank all of you, our, panelists and attendees, but I would like to also thank our teams behind the scenes that have been supporting all the organizations, the ABA, AIJA, the UIA, and IABA, with all the logistic preparations and technical aspects of this webathon.
Ladies and gentlemen, it is an honor to speak with you today. While I regret that I'm unable to connect with you live, as I will be attending the UNESCO's Executive Board session, I am confident that the discussions will be insightful. The theme of this Webathon week is upholding the rule of law in challenging times. Indeed, we are now at a point in history that is both exciting and challenging as we enter the age of artificial intelligence. Simultaneously, humanity continues to face many challenges. Democracy and peaceful coexistence are threatened by hate speech and fake news, while climate change renders our future uncertain. We must decide how we are going to proceed as AI continues to develop and pervade every aspect of our lives, interacting with these challenges and maybe helping us to address them. We need not to look any further than the meteoric rise of the ChatGPT to understand the urgency of this. The platform's growth has been almost unrestrained, reaching almost 1 million users in just 5 days and surpassing many other large-scale technological platforms. So it's not only the pervasiveness, but also the speed of disruption. Global private investment in AI has also risen dramatically, with investment in AI in 2022 being 18 times greater than in 2013. And these figures are, on the one hand, exciting because we know that artificial intelligence can optimize operations, facilitate innovation, increase efficiency, and support, for example, cybersecurity, and help us in tackling some of the world's biggest challenges. AI is a powerful enabling tool in our fight against climate change because it can help us improve emission tracking and modeling, and with its predictive capacities can facilitate the energy transition to renewables by improving solar forecasting. In 2021, the UK National Grid Electricity System Operator signed a deal to create an AI-driven tracking system matching cloud movements to location of solar panels. So this is really, really promising. And AI can also optimize public transportation systems. Artificial intelligence has also proven to be useful in revolutionizing other industries. In healthcare, for example, it can help optimize operations through facilitating early diagnostics and managing health records. You can be 95% accurate with AI and doctors' advice regarding cancer diagnostics, which is an amazing outcome. However, AI also poses significant threats and risks that, if we do not address them, will infringe upon our human rights, threatening our fundamental freedoms, democratic values, and the very world we live in. A lack of precautions against the use of personal and sensitive data risk that such being data co-opted for nefarious purposes like mass surveillance, which is something we forbid in our recommendation at UNESCO. There is also the propensity for AI to replicate and even amplify existing real-world biases, and this can lead to pernicious discriminatory outcomes. And the risk cut across various demographics, including race, gender, youth. Women, who make up only 32% of data and AI professionals globally, are at risk of being further left behind if men continue to be the main creators of the algorithms and of the systems. And additionally, while AI offers much opportunity in tackling climate change, as I described before, it has significant adverse environmental impacts. Training a large language model produces approximately 300,000 kilograms of CO2 emissions. The training run for Blum, an AI data delivery platform, produces emissions worth more than 25 times that of a traveler on a flight before New York to San Francisco. And data centers and digital networks consume about 7% of the world's electricity today, with consumption predicted to increase to 13% in 2030. It is therefore worrying that some continue to believe that self-regulation of AI is enough. Given AI's far-reaching impact, voluntary standards are important, but they are insufficient because they can be disregarded in the pursuit of some other goals, such as profits. To leverage the benefits of AI while managing its risk, we need to center it on the ethics, regulating AI with value-based frameworks and policies that mandate the ex-ante evaluation of the tools. And the UNESCO recommendation on the ethics of artificial intelligence, adopted by 193 member states in 2021, was developed in line with such priorities. It is the first global normative instrument in this domain and serves as a comprehensive framework for the ethical development and use of artificial intelligence across the project lifecycle. Importantly, it centers on values that promote human rights and dignity, which are transformed into principles including of transparency, accountability, the rule of law, to achieve outcomes that are fair, that are inclusive, and that are sustainable. The recommendation, therefore, also takes a strong stance on several fronts. For once, it prohibits mass surveillance and social scoring. It also bans giving legal personality to artificial intelligence, ensuring accountability and human determination. Most importantly, it is not just a general guidance. It includes values and principles that are actionable through recommendations in several policy areas. One such policy area that sets apart the recommendation from other instruments is the environment and ecosystems. We include provisions for member states to reduce the impact of AI systems in the environment, but also to use AI to support environmental flourishing and to use the developments for disaster risk resilience and biodiversity preservations. The sections on data policies, ethical governance and stewardship, and gender, among others, provide concrete policy making guidance to member states' governments. And currently, we are in the process of implementing the recommendation. Last year, we launched two innovative tools, the readiness assessment methodologies and the ethical impact assessment, to know where countries are and where actors are related to the ethical benchmark. The RAM is a diagnostic tool and help countries to be prepared to implement the AI ethically. The results of this assessment will help UNESCO to tailor country-specific capacity building programs to bolster the national AI strategies in the member states. The ethical impact assessment, on the other hand, helps procurers ensure that the AI systems that they are purchasing are aligned with ethical standards included in the UNESCO's recommendation. It contains a section on sustainability, prompting teams to assess how the AI systems will impact the environment or might contribute to environmental flourishing. This is a useful resource across sectors, and I encourage all of you to leverage it upon its wider release. We are now piloting these tools in 40 countries and will be deriving lessons from the debates and from the implementation in all the regions of the world. Our tools were launched at UNESCO inaugural Global Forum on the Ethics of Artificial Intelligence last year, held in Prague, which is the annual conference convening ministers, experts, stakeholders, businesses to discuss best practices and showcase implementation and progress. The next edition will be held in Slovenia, and I hope to see many of you there. While I'm optimistic that our implementation strategy will take us a step closer to ethical design of AI for the whole of humanity, we cannot do this alone. We need efforts from all, from governments, private sector, civil society, and importantly, you, the law professionals. You play a key role in how to frame these issues and ultimately how effective the tools can facilitate ethical AI, translating it into the legal concepts that we all need for democracies to be sustainable. I encourage you to continue to actively consult the recommendation, utilize the tools, liaise with those, but also prioritize ethics and support robust regulations and frameworks. It is only through these that we can truly leverage AI for good, both for humanity and for the natural world around us.
Thank you. Before I give the floor to Sophia to kick us off, so I just wanted to draw your attention to a few key issues that Gabriela put forward as a challenge to all of us. She said that we live in exciting and challenging times where the technology and AI is creating serious disruptions to the way we do things. She also mentioned that AI and technology can be both a force for good and a force for that we can contend with or can lead to human rights violations. Some of the challenges that she mentioned relate to bias in technology and AI. And she mentioned 32% of women are reflected in data, for example. She also made references to the fact that technology can be abused for nefarious purposes, including surveillance. And we know that around the world, especially there are serious environmental concerns in relation to surveillance. We also heard her points in relation to the consumption of electricity, CO2 emissions, the consumption of materials for equipment such as computers, and obviously the need for having technology and AI that is a force for good. She also mentioned AI has a way of addressing some of the environmental challenges that we're facing today, including how we can actually put to a good use AI for disaster resilience. And she stressed, obviously, the importance of lawyers making sure that there is clear accountability and an in the ethical use of AI and other technologies in the world that we live in today. And she also called lawyers to action to make sure that the different regulations in place are abide by and make sure that regulations are not being taken for granted. So in that regard, I wonder, Sophia, if you could kick us off the discussion, because obviously your conversation is going to be around the structural discrimination on the environment. And I can imagine that there are a lot of key points that are stressed by Gabriela that you can also pick up on. Thank you.
Well, thank you very much. In fact, there are many topics that I would like to refer regarding the explanation given by Gabriela in the first video. But first of all, I would like to thank you very much, Inter-American Bar Association, for the opportunity of being here sharing this thought, and Lourdes especially, and all the people that is involved in the organization of this fantastic webathlon. The issue that I would like to talk about is the interrelation between environmental protection and structural discrimination. In order specifically to focus in the idea that the notion of sustainable development requires three dimensions: economic, social, and environmental development, all of them in a balanced and integrated manner as a demand in order to respect the rule of law. The only way to fully fulfill a rule of law and a democratic system is to balance economic, social, and environmental development. And this is the core of the Escazú Agreement, as you know, the regional agreement of access to information, public participation, and justice in environmental matters in Latin America and Caribbean, that was adopted in 2019, since last years. But what I wanted to point out is that this agreement has constitutional hierarchy in many countries of the region. And since that allows us to understand, to read, to give an interpretation of the Constitution according to the principles that are enforced in this agreement. And one of the principles exactly that is shown in this agreement is the idea that the use of IABA technologies, of any kind of communication technologies regarding the system of justice must be done without affecting equality and without discrimination. That is required specifically by the agreement. So we can see that this agreement is not only an agreement regarding environmental rights, but human rights in a complete perspective. So the interrelation between environmental protection and structural discrimination was pointed out by many persons involved in the agreement that we are commenting. We can quote, for example, Antonio Guterres, UN Secretary General, that says that the purpose of the treaty is to fight inequality and discrimination and to guarantee the rights of all the people to a healthy environment and a sustainable development, paying special attention to vulnerable people and groups, and placing equality as the center of sustainable development. We can also quote Alicia Bercena, the Executive Secretary of the Economic Commission for Latin America and the Caribbean, CEPAL, that says that the treaty confronts one of the most important challenges in the region: the source of inequality and a deeply entrenched culture of privilege. And it's interesting because this aspect were pointed out before the pandemic situation, that actually we visualized and showed in a very, very dramatic way how the structural discrimination was even getting worse with the pandemic situation. So the problem is that according this demanded, what we need from the constitutional perspective in order to enforce a rule of law is to rethink, redefine what do we mean when we protect equality. Constitutionalism and international order of human rights have focused discrimination for many centuries. It is emphatically proclaimed in constitutional law, conventions, declarations, but however, the reality is plagued by groups of people that are marginalized, excluded from the enjoyment of their rights, and even drowned in violence and misery. So this scenario constitutes structural discrimination. that is a systematic situation of exclusion, marginalization, subordination that prevents a group of people from accessing basic condition of human development. This is the definition of structural discrimination that is declared by the Inter-American Court of Human Rights in one case in 2016, the case against Brazil regarding slave work. People who are in a situation of submission by virtue of multiple structural causes with detrimental of their quality of life. And it is precisely towards the modification of such structural condition that the jurisdiction responses that the remedies should be projected. Although these situations are not new, their consideration and conceptualization and fight by the legal order, yes, is really new. It's a new approach, it's a new concept. So we need to, as I said before, redefine and rethink about what do we talk when we talk about equality. As we know, equality traditionally was conceived with a formal perspective that demanded the neutrality of the state in such a way that the state is not allowed to formulate distinctions. But with the adoption of the new constitutional reforms within the scope of social constitutionalism since the beginning of the 20th century, we can quote, for example, the Constitution of Querétaro in 1917, Constitution of Weimar in 1920, and many reforms that went worldwide after Second World War. That constitutional socialists or social constitutionalism allow the progress towards a substantial perspective of equality. And in such orientation, Constitution recognized more generous treatment to some specific groups who receive preferential protection. At the beginning were the workers, but later it was included children, people with disabilities, elderly, among others. This is how the principle of neutrality actually advances towards the principle of anti-discrimination, quoting, for example, Owen Fisk. But the interesting product that we can find in the jurisprudence of the Inter-American Court of Human Rights that are very useful for the constitutional courts in order to approach this situation are 4 different concepts that I would like to share with you. The first is indirect factual discrimination, multiple discrimination, intersectional discrimination, and finally, structural discrimination. Those 4 concepts are related between each other, but we need to make some specific perspective in order to find out how is which kind of remedy is demanded by each concept itself. So the first concept, is indirect discrimination. It means that the concept of equality does not only is affected when the law or the legislation by itself is discriminatory, but is also affected when there are forms of discrimination that don't derive directly from the law or the legislation, but it are generated by the projection of the law in the facts. Despite legislative neutrality, we can have a neutral legislation, but when it's projected to the reality, to the society, this kind of law that appears to be neutral generates a major impact in a group specifically vulnerable. So that is known by the Inter-American Court of Human Rights as indirect discrimination. The 2 other concepts that were, concepts that arise before structural discrimination are multiple discrimination and intersectional discrimination. They are very similar, but they differ in one specific aspect. Multiple discrimination, we can find it, for example, in the case González-Llull versus Ecuador in the Inter-American Court of Human Rights, says that several vulnerability factors associated, for example, with conditions such as age, sex, poverty, disability, health, among others, these several vulnerability factors converge in such a way that the legislature or a practice from a state or not a state actions have a disproportionate impact in a group. So all the factors acts in a combined way, and the legislature or the practice generate a specific and worse impact in a group. The intersectional discrimination seeks to describe a situation also where various discriminatory motives intervene and they interact with each other, but a specific intent of intersectional discrimination is to show that when all these different factors interact together, what we get is a different kind of discrimination. It's a specific kind of discrimination that requires a specific kind of response. That's why the Inter-American Court of Human Rights refers to the differential perspective in order to address the intersectional discrimination. So, for example, the remedies that are going to be issued by the constitutional jurisdiction have to be different for each kind of intersexual discrimination and have to take into account the particular circumstances of each group that suffers these multiple kind of factors that generates its discrimination. And finally, especially after 2016, the Inter-American Court of Human Rights developed the idea of structural discrimination that refers, as I said before, to the systematic and historical situation of exclusion, exclusion, marginalization, or subordination that prevents a group of people from accessing to basic conditions of human development. This idea of structural discrimination began to be considered by the Inter-American Court of Human Rights regarding 2003. But it was the first time that was used was in year 2009 in a case regarding gender equality, women's rights, that was Campo Algodonero, case González versus Mexico. And the interesting thing was that the Inter-American Court referred to the culture of discrimination as a problem that generate the responsibility, international responsibility of the state of Mexico. And it referred to the culture of discrimination that was known by the state. And this culture of the discrimination put the group on a special risk and demand that the remedies that the state must adopt, procedural remedies, need to have a vocation to transform the situation. So the concept of a structural discrimination demands that the remedies that are carried out by the judicial power must try to transform the situation, transform the social culture of discrimination. The consolidation of the doctrine of structural discrimination was done in 2016 in the case is Trabajadores de la Fazenda Brasil Verde. It's a case about, as I say, slave work. And the interesting thing there is that the Inter-American Court linked the idea of structural discrimination with poverty. This is pointed out by Eduardo Ferrer MacGregor in his particular vote. But finally, the topic was again raised by the Inter-American Court in a case adopted also against Brazil, and also referring women's rights, where it says that this structural discrimination is not only a scenario, a framework that allows the violation of the human rights. That was considered in 2016, but in 2020, in this case, regarding the employee in a firework fabric, against Brazil, it says that structural discrimination by itself is related to intersectional discrimination and is a violation of Article 24 of the Inter-American Convention of Human Rights. Now, structural discrimination is a violation of Article 24, is a violation of human rights, and demands to all states part of the system to adopt remedies that can transform the situation, that can transform the society when this structural discrimination is sustained in discriminatory stereotypes. And in this decision regarding Brazil, it appears for the first time the notion of differential approach that demands that the consideration of each situation of a structural discrimination requires a differential approach, requires remedies that take into account the specific condition of each case of a structural discrimination. As we analyze this concept of structural discrimination, we can easily conclude that this is the concept of equality that is used by Escazú Agreement. If we see the prologue, for example, it says that the agreement is adopted, reaffirming the importance of the Universal Declaration of Rights and recalling other international human rights instruments that underscore to all states to have responsibility to respect, protect, and promote human rights as a fundamental freedom for all without distinction of any kind, including those related to race, color, sex, language, religion, political or other position, opinion, national or social origin, property, right, or status. But specifically, the Escazú Agreement refers in Article 2E that persons or group in vulnerable situation means those persons or group that face particular difficulties in fully exercise the access of rights recognized in the agreement. And also in Article 8.5, it says that in order to give effect to the right of access to justice, each party shall meet the needs of persons or groups in vulnerable situation by establishing support mechanisms, including as appropriate free technical and legal assistance. So we have the idea that is surrounding these two topics, that environmental protection and structural discrimination has theoretical and factual complementarity. They both share the same dimension. They both are structural. They have a polycentric and complex causality. In both cases, environmental protection and structural discrimination is impossible to reduce the conflict to only one cause. Generally, conflict is sustained in a structural way with the systematic patterns with several cases that are related between each other, with many centers of tension that interact, maintaining the violation. That is considered by the scholars as polycentric, a pluricausal phenomenon. It's represented as a spider web that sustains this kind of violation along the years. So they also interact, environmental protection and structural discrimination, as reciprocal cases, the frustration of the right to live in a healthy environment constitutes by itself a structural element that determines structural discrimination. The group that lives in this unhealthy environment is subjected to structural discrimination. And they have also practical implication. In complete cases related to environmental law, the situation of vulnerable groups that suffer structural discrimination is also involved in a relevant manner. And this is shown in many cases that were that arises in constitutional courts in Latin America. We can see in Colombia, we can also see in Argentina. We have specifically one important case, thank you, that is called Mendoza. Is a complex litigation. It was an environmental case brought to the Supreme Court, but by a group of people living close to a watershed that was extremely polluted. It was a very important river in Argentina, and they demand the recomposition of the river, but also they demand the guarantee of the quality of life of the people that habits in this region, and that was issued by the Supreme Court. So there you can find that the only way to protect and to assess the conflict by itself was combining the protection of the environmental issue, but also the structural discrimination. The structural decision was adopted in 2008. There were many public policies regarding especially the quality of life of the people there. The program, there was designed a program with many orders.
Oh, have we lost Sophia?
That
she's back.
I'm sorry, I'm here again. Sorry, yes. I'm just finishing. 1 minute. That was the first structural case in the Supreme Court of Argentina. It was in 2008. It's still on. The case is not finished. As we know, a structural case take a lot of decades. But after that, a lot of cases were arise regarding similar questions. The problem is that in Argentina, as in the rest of the countries of the nation, there is no legislation that refers to this case of complex causes. So the judicial power doesn't have the technical elements, the technical tools to approach to this kind of complex situation. We need adequate remedies because the Inter-American Convention of Human Rights demands us to have in Article 25 effective remedies in order to protect the violation of rights. And if the violation of equality is done in a structural way, the remedy has to be also structural to be effective. What does it mean? A structural debate where everybody that is involved in the multicultural conflict is part of the debate. The debate has to be dynamic. The debate has to be progressive. The debate done in the judiciary needs to show the movie, not only a static picture of the conflict. And it's necessary that the judge has case management, can adapt the process to the conflict. And finally, the decision has also to be structural, has to be dynamic, has to be progressive, and has to adopt multi-sectoral order that involves all the departments and even the society that might be a cause of structural discrimination and environmental violation of rights. Well, thank you very much. And sorry if I take a little bit of time, and thank you very much for the invitation.
Thank you, Sophia, and thank you for giving us such a fantastic and rich and varied jurisprudence and case law in your presentation. Certainly, I will be trying to hone up those skills in order and refer back to your presentation indeed. I just want to draw the audience to a couple of points that I think are very relevant for our next presentation. Sophia made references to the fact that the reality shows us that many groups of people find themselves in a systematic and historical situation of exclusion, marginalization, and subordination that prevents them from accessing basic conditions of human development. And that is the key or the node of where the interrelationship between environmental protection and an updated notion of discrimination takes place, and therefore that could lead potentially to that structural discrimination that Sophia clearly emphasized throughout. She also mentioned several types of discrimination: indirect factual discrimination, multiple discrimination, intersectional discrimination that leads to that structural discrimination. And she makes a very strong argument of the notion that sustainable development requires the three dimensions, the economic, the social, the environmental, in a balanced and integrated manner, has a demand in order to respect the rule of law. So thank you for all those key points, and certainly those could be the basis of many, many debates to come. But that leads us perfectly well to our next speaker, Daniel Sumalavia, who will be, in fact, and I rectify my previous remark, he will be actually speaking to us about building sustainable futures in the Amazon, strengthening environmental governance, human rights, and peace building efforts. I am sure this is also going to be a notable presentation. Daniel, the floor is yours.
Hello, Lisette. Hello, everyone. Thank you so much for having me. I would like to share a very short PowerPoint just to follow my presentation. And I want to start, of course, thanking everyone for being here with us. Thank you for the organizers for their invitation, in particular to the Inter-American Bar Association. Thank you so much to Lourdes and to Lisette who host this space for us to share. And I'm very pleased that I have the opportunity to present after Sophia, because her presentation is very connected, because she was giving a call of action for us to rethink and to redefine our understanding of equality. And I think that I will try to give a presentation based on a very particular context, which is the Amazon region, which is a very complex context, and where structural discrimination is a very important fact on how the challenges of environmental protection we have in our territories. Okay, no problem. I won't follow the presentation. I will just keep the text going. So just to give a little bit of context and an overview about the Amazon region. The Amazon region is one of the world's most important regions in terms of ecological, cultural, and social significance. It's shared by 9 countries in South America, and it is the largest tropical rainforest in the world. Home to an estimate of 10% of all the world known biodiversity, including endangered and endemic species. It is also home to around 30 million people, most of which depends on the forest and the rivers and the resources for the livelihood and subsistence. In this diversity of people, and this is why I mentioned the connection with Sophia's presentation just worked perfectly. We have a very strong and important and diverse of indigenous people and Afro-descendant communities in the Amazon region, in the Amazon countries. We have over 350 different indigenous peoples in the region with their own diverse languages, cultures, and traditions. And to mention some examples to just have in mind this ethnic diversity, only Brazil have over 150 different indigenous languages. Peru in the Amazon region have 43 and Colombia have 51. So it's very important to bear this in mind because we are discussing about the rule of law and protection of the environment. And as Sophia was mentioning, how complex the legal structure and the development on the understanding of structural discrimination during the decades were evolving, is also important for me to try to put us on the same page on how hard is to apply the rule of law in an efficient way in complex situations as this one. So we have a very important, diverse environment in terms of ecological importance, but also in terms of cultural diversity. So this presents a lot of challenges for the implementation of law, for the rule of law, and for the protection, because we are clear, and this is something also that connects with Gabriela's opening remarks and with Sophia's presentation, that the legal framework is there. We have a lot of important cases on the Inter-American system of human rights. The right of indigenous people, for example, have been progressively given more attention by the UN system to. This decade is International Decade of Indigenous Languages that goes from 2023 to 2032. So, but besides all that, indigenous peoples continue to be left behind and suffer disproportionality against climate change, environmental degradation, high levels of poverty, poor access to education, health, and broader human rights violations. So there's a gap between what we have on our legal systems to the implementation, to an effective implementation of those frameworks. And in particular, and this is another topic that has been mentioned before, but I think is always key to highlight, is that indigenous women in particular are more vulnerable together with indigenous youth because they have disproportionately impacts by the lack of access to education and employment opportunities, the lack of participation on the decision-making processes, and access to justice. So as Sophia was mentioning, this structural discrimination also requires an intersectional approach, because we need to consider how the different levels of how this structural discrimination affects different levels of people in different levels, indigenous women with a disability, indigenous youth, and Afro-descendant communities also living in our region. So to go a little bit after all this great diversity that we have in the Amazon, this region faces very hard threats that goes from some illegal activities to sometimes legal activities that not only contribute to ecological degradation and to climate change, but also have significant social and economic impacts, including human rights violation, conflict, and displacement, as it was mentioned before. As such, the Amazon region is an important site of global concern and a critical area to analyze and to put into reflection environmental governance, human rights, and protection, and also the peace-building efforts that we have in our countries. Some activities that threaten the region includes illegal logging, illegal mining, narco-traffic, wildlife trafficking, but also, and as I mentioned, there are some legal activities, legal concessions for mining, oil, gas exploration and extraction, infrastructure projects such as road, dams, and hydroelectrical plants, and threatening the biological and cultural diversity of the region, because in some cases, the due diligence on social and environmental safeguards that are part of our legislation are not fully applied. So these factors can also be a direct cause that exacerbates social conflicts and threaten human rights. So we give some examples and some figures that helps us understanding the level of the impact of these threats. Just to mention the example of illegal mining, in 2019, the Amazon Social Environmental Georeference Information Project, RISE, released a study that identified 2,312 illegal mining sites across 6 countries in the region: Brazil, Bolivia, Colombia, Peru, Ecuador, and Venezuela. 2,000 specific areas where illegal mining was affecting forests, rivers, lands, and threatening the life of the people living around those sites. One related threat to this illegal mining also is the mercury that is used in gold extraction. And of course, we have all of our countries in the region are part of the Minamata Convention on the use to try to protect people from being affected by mercury. But besides that, there are several studies that is showing us how indigenous and local populations who live near these sites are being affected. One of the worst hit areas, for example, is the home of the Yanomami indigenous peoples who live in the territories between Brazil and Venezuela, which in some cases are suffering from alarming rates of mercury poisoning. The National School of Public Health, Sergio Arauca and Fiocruz in Brazil, released in 2019 a study they made in communities of the region of Maturacá in the state of Amazonas, and they found from all the Yanomami indigenous people that participate in the study that 56%, half of the people that participate, women and children, were contaminated with mercury. So we also have a very similar situation in another border region in Madre de Dios in Peru, which is a border with Brazil and Bolivia, where several studies indicate that the presence of mercury in fishes that are part of the diet of the communities exceed in most of the double the time of the limit established by the World Health Organization. So I want this to make us think about the impacts of this structural discrimination that we're reflecting on before, how it can be so threatening to the life of the communities, and how the limitations of access to this, to access of justice, as we were mentioning, is also making these situations more every time and continuously, historically, more threatening. Last year, another report from the Monitoring of Andean Amazon Project, MAP, estimates that 13% of the original Amazon forest biome has been lost due to deforestation and other causes. So according to scientists, the Amazon is getting dangerously close to a tipping point. Professor Carlos Nobre and Professor Lovejoy has done extensively provide scientific information and evidence that we are getting to a point where the Amazon can transform to a thriving tropical rainforest into an arid and impoverished savanna. So we need to stop it now. So there is a call of action, but that is not new. It has begun decades ago, but it becomes urgent and urgent every time. So they predict that this irreversible shift could happen once the forest loss reaches 25%. And we are very close. In some regions in Brazil, you're already getting close to that number. So this threatens not only affects biodiversity and the life of communities depending on the forest, and these include very particular groups, for example, indigenous people in situation of voluntary isolation and initial contact. And this is where this intersectional approach and a different response to complex and different and diverse realities has to be put in place. And also indigenous women and men that are constantly defending their territories, their forests, and their river are being under life threats. Sofia mentioned the Acuerdo de Escazú, and I think the Escazú agreement is a great opportunity for us to directly address this problematic, because Global Witness in 2019 reported that 98 environmental leaders were killed only in the countries of the Amazon region. And this is a permanent threat to our lives. In our case, working directly with indigenous communities, we have to be very aware of how our actions and initiatives have an impact on their lives. And that's why I want to give this broad overview of one very specific region, because the rule of law is critical for the Amazon. But also that I want to give an open invitation that we approach the rule of law beyond just the law and the lawyers. And this is why I take the words of Sofia when she says we have to rethink and redefine, and we need to rethink and redefine how we approach to the rule of law too, because it's a critical component of effective environmental governance, human rights protection, and a peace building in a complex context like this one, but also to other regions in the world. But this challenging context require approaching a social and environmental legal frameworks in the region that we know that sometimes are strengthened and then weakened depending on the political context and particular interest. So we have to address a very complex situation, and that is very connected to our political instability in the countries on the region too. So for sustainable and effective rule of law requires a multi-stakeholder, a multi-level, and especially a multidisciplinary approach. And I want, in this minutes that I have left, I want to give a few examples that are also connected to the previous presentations of Gabriela and Sofia, because, for example, I want to highlight the importance of science to addressing environmental challenges in the region and in the world, because we need to strengthen and research institutes in the region. There are many very great experience in Colombia, in Peru, and in Brazil, but they need more resources. They need to empower local scientists, indigenous scientists, to be able to provide and to give us updated information on the state of the region and environmental science. There's another great initiative that I want to share with you, which is the Science Panel for the Amazon. That's a group of over 240 preeminent scientists from around the world, a lot of them from the Amazon countries, and indigenous members that deliver a comprehensive, first of its kind scientific assessment of the state of the Amazon, current trends, and recommendations for long-term sustainability. But what I appreciate a lot on the information of the Science Panel of the Amazon is that it's science written from not scientists. And it's something that I also call to myself when we talk about lawyers. The multidisciplinary approach requires us to be able to communicate in an effective way the information and the knowledge we want to share. And this, especially working in complex and multicultural environments, we need to be very aware of that. Another component for an effective rule of law is a strong legal framework. And this should be based on the principle of participation. And of course, under the ILO 169 Convention, in the case of indigenous people, it includes free, prior, and informed consultant. But to empower these affected communities to have meaningful voices in decisions that affect their territories and their lives, we need to be aware that these require a multicultural approach. We're talking about linguistic diversity and linguistic rights. So we cannot address an open dialogue and a real effective participation if we don't provide the indigenous communities with ways to have this open dialogue in their own language, with their own terms, and in a clear understanding and transparency between the parts. One good example in Peru is the National Registry of Interpreters and Translators of Indigenous Languages, which now have over 400 interpreters and translators of 37 of the 48 indigenous languages in the country, which is a step forward to promote an effective dialogue and intercultural approach. So we need to see more of these initiatives. And also connected to one of the previous, to the opening remarks, the importance of how to include new technologies on the effective rule of law and the enforcement mechanism to ensure compliance of environmental laws and regulations. One of the systems that are very that are used more extensively on the region, on the Amazon region, sorry, is georeference systems. One example is the use of early warning system that detect deforestation based on optical satellite data and provide key information to law enforcement mechanisms in Brazil and Peru, but also community-based forest monitoring. So you have indigenous and local communities where are trained by the governments and civil society in the use of drones and mechanisms using cell phones. For example, the Ecuador Shuararutan indigenous people, that they have a particular community-based monitoring system that collects information from indigenous monitors with Android cell phones and tablets, and then uploaded to a virtual platform. And this information for them is used to a better decision-making process and political advocacy to protect their territories. So incorporation of new technologies is key at different levels, and it's open accessibility. But as Gabriela mentioned in the opening remarks, we need to be very aware of the ethical behind the use of these technologies too. Another important key, and just getting close to finishing the presentation with this, is a system with appropriate penalties and sanctions for non-compliance to ensure an effective law enforcement. which is another important aspect. And this topic also, I want to share some very interesting initiatives that are taking place in the Amazon region. There's one illegal mining calculator, which is a digital economic valuation tool that allow the users to calculate the social and environmental impact of illegal gold mining in the Amazon. That was developed in Brazil by the Conservation Strategy Fund, and now is being used by the Brazilian Public Prosecutor Office and the Federal Police to make a better valuation of the impact of gold mining in Brazil. This initiative is also being supported to be replicated in Peru and in Colombia. What I'm trying also to do, but mention this example in border regions, is how the threats on the environment goes beyond the national limits. So they go beyond the national legal frameworks. So we need to address them regionally in a broader and coordinated and articulated effort. The last aspect that I want to share with you, I want to open many doors so then we can further discuss in the Q&A and in other spaces, is how the peace building efforts related to environment governance, especially in conflict and post-conflict scenarios in the Amazon, for example, in Colombia, are very interesting challenges for the rule of law. In Colombia, the environmental peace building includes addressing ineffective land use planning, the return of displaced population and farming communities, and the overdependence of mining and other extractive activities for economic development. So now in place, there are key efforts that have been developed, for example, in cases in Colombia where with this post-conflict and displaced population that's getting back for their communities are given opportunities to avoid working on illegal mining. That was one of the threats on the territories in Colombia, or illegal logging, and to work together with the communities they're getting back to on sustainable development initiatives, on productive sustainable development initiatives to protect the forest and to keep the forest in place and with alternative mechanisms. But this require capacity building, this require a clear legal framework for them to readapt to this situation. So this was a very quick overview of some aspects that I want to share with you on this complex topic that we are raising. Was a challenging topic, but I think these kind of events and the opportunity to be working with young lawyers, international and multidisciplinary efforts in the region is key for us to start giving a call to action and also enriching our view from different perspectives on how to address the rule of law. This is all from my side. I'm very close to the finish of my time, so I'm very glad again for your invitation, and I keep open to any question that you have on the audience. Thank you.
Thank you, Daniel. And rather than trying to summarize such a fantastic presentation from Daniel and his case study that is very, very rich, I would like to draw now your attention to another fantastic presentation from Julian Newman from the Environmental Investigation Agency, and he will be talking to us about the costing the earth, tackling environmental crime. Over to you, Julian.
Thanks very much. Thanks to the organisers for inviting EIA to take part, and greetings to you all from London. As the title suggests, I want to talk to you a little bit about environmental crime. Now, there's no single definition of what environmental crime is, but generally it encompasses a range of damage to the environment, including illegal trade in endangered species, illegal logging, illegal and unreported, unregulated fishing, and pollution crimes such as waste crimes and emissions and these sorts of things. So environmental crime is quite broad. It's been said to be the fourth largest form of transnational organised crime in the world after narcotics, people and weapons. It's grown quite rapidly. It's hard to always put a scale on these problems because things like illegal markets and criminals don't tend to do tax returns, so it can be quite difficult to get a sense of the scale of these crimes. But some well-respected sources have sort of said that the illegal exploitation of timber, wildlife and fish generates up to $280 billion a year in criminal profits. That is a lot of money. If we just look at illegal logging, today I want to speak to you mostly about forests and illegal logging. Illegal logging and the associated trade in illegal timber is valued at about 30%, 30% of the whole sector. So that means about a third of all the timber that's being logged and sold is probably highly likely to be illegal. That's a huge number. And again, to put a ballpark figure on it, research has shown that illegal logging and forest destruction that's illegal generates up to $150 billion a year in profits for criminals. So you can see protecting the earth is a challenge because there's so much money being made out of it, both legally but also illegally. And just to give you one more example from the world of forests, the total tropical forest loss between 2013 and 2019 was 77 million hectares, a huge area. 60% of that clearance was not due just to timber, it was due to clearance for agriculture. That's a growing trend all around the world, we see, replacement of forests with agribusiness activities. And about 70% of that conversion of forest into arable land or farming land was illegal under national laws. So what we're seeing is there's quite a few laws in place in many countries to try and protect forests, but really they're not really being enforced very well at all. Which brings us onto the legal basis. So when we look at environmental crime, a lot of these crimes are transboundary crimes, cross-border crimes. Often a tree might be felled in the Amazon, but it often be traded across the world to China or Japan for products. So it's truly a global crime that we have here. And in response, we have global agreements. We have a series of global international environmental agreements that are supposed to help countries come together, work together, cooperate to protect the environment. One of these is the United Nations Convention on International Trade in Endangered Species, commonly known as CITES. And CITES regulates trade in a whole range of animal species, reptiles, but also timber. So timber species are often listed on CITES when they're being overlogged. And CITES works by basically having two appendices. Appendix 2 in CITES means the species is threatened, but trade can continue in that species as long as it's got permits. Whereas Appendix 1 means a total international ban on trade in that species. So for example, there's a type of rosewood, very, very lucrative, very popular, that was put on CITES 6 years ago. It was originally on Appendix 2. That didn't work very well, so it's now on Appendix 1. So you can see it can go up to scale if things aren't working well. So CITES is really the only international mechanism we have for controlling trade in timber. For example, there's no global agreement on timber. So what we have is we have these overarching international agreements, which are all well intended, but sometimes the compliance and enforcement of these conventions can be somewhat challenging or not very efficient, because often people don't put the work in to do the work to make the conventions work. But also international agreements have to be transposed into national law. So any country which is a member of CITES can go along and agree all these things, then they have to be put into national law. And in many cases, when you look at national laws on the environment, they're either often weak, or the penalties are quite small, or they're not enforced very well. They're often not seen as a priority for governments, despite all the threats we know environmental crimes pose to the world, from climate change to biodiversity loss, to pollution. We all know the threats posed, but often governments do not prioritize enforcement against environmental criminals when they look at their response to crime generally. There is a new kind of area of law emerging when we look at forest crime. That is what we can call demand-side measures. Demand-side measures are where the markets are trying to influence activities upstream where the products are being produced. This has happened in the past with the European Union. The European Union in 2013 had in place a thing called a timber regulation. Under that timber regulation, for the first time anywhere in the world really, if a tree was logged illegally in a foreign country and sent to the European Union, it could launch a criminal investigation. There haven't been many cases like that, but what it does have is it has a very important due diligence requirement. That requirement states that anyone importing timber products into the EU must have taken steps to look into the origin of these species and the legality of these species. And if you can't do the due diligence adequately, you're not supposed to buy the wood. This is an example of where markets are trying to have a longer arm into the actual producer countries because they are not always confident producer countries' procedures are correct. This has recently been expanded in the European Union to a regulation on deforestation. As I've said before, loss of forest is not just about chopping trees down, it's about conversion into things like palm oil plantations, soya plantations, cocoa. Many commodities replace the forests. So the European Union has recently agreed new regulations that will make it a responsibility of companies to know their supply chain and to avoid any supplies which are linked to illegal deforestation historically, but also new deforestation. Now, this law is very forward-thinking. It's going to be a challenge to implement because obviously it relies on information from the source country. But with satellites these days and local NGOs, there are ways of tracking these developments in country. There's also been a negative reaction, as you might well expect, from some of the countries that produce these products, such as Indonesia and Malaysia, which are the world's biggest producers of palm oil. And they see this as some sort of form of latent colonialism. So hopefully there'll be discussion, there'll be explained well, that the intent of this law is not to punish those countries, it's to try and help them save their precious forests, which they're all committed to do. So these rules are quite new, but it's an interesting new approach to try to look at the chance of using market access to improve procedures upstream. So that's where we're at in terms of the scale of the crime, the legal basis. I just want to mention, follow up on something that Daniel said earlier as well. When we look at forest crime particularly, often the biggest victims are those people living in forests, forest communities, the local people, the indigenous communities, who are often intimidated or criminalized or threatened to try and protect their ancestral or their lands. And just to reference what Daniel referenced, Global Witness is an excellent NGO in the UK. They've been doing a lot of research since 2012, trying to document deaths, disappearances, injuries to environmental and land defenders. And in that time, since 2012, they've documented 1,700 cases of people being killed for trying to protect their land and their forests. It's a shocking number, tragic. The biggest number of cases is in Brazil, 342. The biggest country in Asia was the Philippines, which had 270 deaths. And Africa, the Democratic Republic of Congo, had 70 deaths during that period. So, and the biggest, when Global Witness analysed these deaths, the biggest cause was conflict over development of land, basically, for agribusiness, logging, mining, basically for resources. So often these local communities are standing in the way of lucrative opportunities for companies, often backed by the government, to make money out of agribusiness or mining or dams. And really the authorities are often absent, they're not doing their job. So it's left to these communities to try and defend their lands, and often the stories don't end well because they get no support. Just want to add one last thing, just a couple of case studies from EIA's work, just to show you some of the frustrations we have when we're trying to curb environmental crime. There's a country called Myanmar in Asia. Myanmar has a wood species called teak, T-E-A-K. Teak is very, very precious wood. It's a beautiful wood. Burma has the biggest supply of this natural teak. It's often used on yacht decks, particularly for oligarchs like it a lot, particularly. It's a beautiful wood. It is managed inside Myanmar by a government company called Myanmar Timber Enterprise, which is a government company. After the awful coup that took place in Myanmar in February 2021 by the military, the US, EU, and UK all moved quite swiftly to put sanctions on Myanmar, in essence to try and cut off monetary supplies to the murderous junta who was using them to kill its own people. Despite the MTE being on that sanctions list, there is still an ongoing trade in Burmese teak coming out from Burma and going into America and going to Europe, despite the fact that the only body in Myanmar that deals with this product is sanctioned. So I'm not an expert on sanctions, so if anyone out there on this call wants to give me some advice on how to implement sanctions because they're not working so far, I'll be grateful to receive that. And a couple more cases just to show the scale of these things. few years ago, we did some work into illegal logging in Cambodia in Southeast Asia. We found that there was extensive logging of protected areas, national parks in Cambodia, and the timber was being smuggled, well, not really smuggled, it was openly being taken across the border through bribery. Altogether, there's about 300,000 cubic meters of timber were logged through this illicit deal, and $45 per cubic meter was paid in bribes and kickbacks that went up to the very highest level of regional government in Vietnam, with the governor of the province implicated. And that sort of equates to around about, I think, where are we? Yeah, that's about $13 million was paid in kickbacks to Vietnamese and Lao officials to get that wood across into the market. So I'll leave it at that. I could tell you some more anecdotes and stories, but I think we're running behind time. So thanks for your listening, and I'm around any questions you might have. I'll hope to try and answer. Thank you.
Thank you, Julian. Julian, I won't try to summarize some of the fantastic case studies that Julian brought to the fore, and to raise our awareness about what is going on in the world of illegal crime, and especially illegal logging. But I would like to sort of now pass on to our next panelist, Thomas O'Keefe, who will be talking to us about his work. Thank you.
All right, well, thank you very much. I'm not going to have very much time to go into detail about all the intricacies of consultation, particularly consultation with indigenous communities. But there is a brand new book that just came out that was published by the American Bar Association International Law Section, a guide to human rights due diligence for lawyers. And in there, you will find a whole chapter on the obligations of consultations with indigenous peoples and what it entails. The reason why we're concentrating on this whole topic of consultation is because we're trying to ultimately avoid conflicts that arise when people's environmental rights, particularly the right to a healthy environment, for example, are trampled on. And so one way to try to avoid that is consultation. Consultation is a concept that actually has been incorporated now into the environmental impact assessment reports that are required when companies, for example, are about to embark on an investment project that may have detrimental environmental impacts. And that obligation actually, it's actually set by a domestic law, but the origins of it actually come out of the Convention on Biological Diversity that was signed back in 1992 in Rio, the famous Earth Summit. Although I want to underscore that suggestion in the convention about allowing for public participation in environmental impact assessments is voluntary. It's not obligatory. I also want to point out something else that's very interesting about that convention. The United States attended the conference in the form of George H.W. Bush. It was one of the few countries in the world that left that summit without signing the convention. It was eventually signed by his successor, Bill Clinton, in 1993. That the United States alone, out of about 196 countries in the world, has never ratified the Convention on Biodiversity. But what I'm going to focus on is consultations with indigenous peoples. And there, that is an obligation under international law. For those countries that have signed what has been previously raised by Danielle, ILO Convention 169, International Labor Organization Convention 169, that requires prior consultation with indigenous peoples. There is also, since 2007, as a result of the UN Declaration on the Rights of Indigenous People, an obligation of free, prior, and informed consent. Prior consultation and free, prior, and informed consent are often put together. They're two separate concepts. It's also important to underscore the UN Declaration on the Rights of Indigenous People for most countries in the world is voluntary also. It's not obligatory. The only countries that have it as part of an obligation are those that have actually incorporated it into their domestic law. One of those countries that did incorporate free, prior, and informed consent into its constitution was Bolivia. Although let me underscore that in 2011, despite the existence of free, prior, and informed consent, the government of Evo Morales permitted a highway to be built with Brazilian funding through a indigenous reserve, the Tipnas. And what that did was basically pitted two sets of indigenous peoples. The Aymara and Quechua speakers involved in coca production, who formed the base of the constituency of Evo Morales, or did, and his MAS party, and those indigenous peoples living in the Tipnas. And of course, the ones who got the upper hand were the ones with the bigger group, which was the coca producers. And the reason why they were interested in this highway being built, it was a way, obviously, to facilitate production in this reserved area, a biological reserve and a reserve for indigenous peoples, and more easily transporting it to markets as well, too. Okay, so just the fact that you have free, prior, and informed consent doesn't necessarily mean the governments adhere to it. And so let me just quickly, I just want to underscore just by showing this. So those are the two international conventions or declarations that we're talking about. Indigenous and Tribal Peoples Convention, that's ILO 169, that requires prior consultation. 23 countries have ratified it. The vast majority of them are in the Western Hemisphere. And they started ratifying in the early 1990s. And despite that, we still have lots of issues in terms of, for example, what exactly does consultation mean? Is it the company, the obligation is on the part of the government. And I'll talk about how the private sector gets involved in this in a minute. But the obligation is incumbent on the government. Is it government officials who show up in an indigenous community and basically show them a PowerPoint and tell them what they're going to do, or is it actually sitting down and discussing with these people? And if you're sitting down and discussing with these people, as Danielle pointed out, it's not good enough to speak in Portuguese or to speak in Spanish. I mean, you have to know the indigenous language to be able to communicate with people to ensure that this consultation is going to be adequate and is going to be effective. We've had this whole issue as well about what exactly is prior consultation. Is it before the government even considers an application to approve an investment project in an area that's going to detrimentally impact indigenous peoples? Or is it after the approval has been already authorized by the government, but before the project begins? So we have all these questions that have arisen over the years. The Inter-American Court of Human Rights in particular has been one institution that has been trying to define this through its decisions over the years. The Inter-American Commission on Human Rights, through its recommendations, has also done that as well. But we still have lots of areas where it's unclear about what exactly we're talking about when we talk about consultation. Now, as I mentioned before, the UN Declaration on the Rights of Indigenous People is voluntary, except for those countries that actually have incorporated free, prior, and informed consent into their domestic law. But here again, the fact that it is in the Constitution doesn't necessarily mean it's going to be adhered to or followed. But we also have issues that have come up in terms of what free, prior, and informed consent means. Ultimately, if an indigenous community no matter how much a government has tried to convince them that this is something worthwhile for them, that they are going to benefit from this because the government, in trying to get their consent, is going to offer building new schools, building new roads, building new housing. If ultimately the indigenous community still is not interested and says no, does the indigenous community have the right to say no? Does it have veto power? That's a huge issue that still hasn't been resolved yet. And the consensus of most governments who signed on to the UN Declaration on the Rights of Indigenous Peoples is there is no veto power. Because to give veto power to an indigenous community would, in essence, give them sovereignty. And most governments, particularly in Latin America, they have a serious issue with indigenous sovereignty, indigenous autonomy. That issue has been, it's more, it's handled in a different way in North America and Canada and the United States in particular. Of course, the irony there is both Canada and the United States have never ratified ILO Convention 169, and they actually voted against the UN Declaration on the Rights of Indigenous People. Only 4 countries in the world, Canada and the US, Australia, New Zealand, voted against the UN Declaration on the Rights of Indigenous People when it was put up to a vote in the General Assembly in 2007. But despite that, at least there is more of an understanding of autonomy and sovereignty. Unfortunately, that's not the case in Latin America, and we just saw this last year in Chile. One of the reasons the proposed constitution was voted down was this whole issue of what exactly, what rights in terms of autonomy the Mapuche people were going to be given under this constitution. And for most Chileans, it was going too far. It was, of course, the right-wing controlled media in Chile also manipulated the debate by planting a lot of false news stories out there as well too. But in the end, it was voted down. Okay, and there are practical consequences, by the way, when the governments don't adequately consult with their indigenous peoples. Any of you who follow the news know that starting in Mexico, going all the way through the Central American Isthmus, down through the Andean mountains and into Argentina, Paraguay, Brazil. There are lots of projects, investment projects, mining projects, energy projects, renewable energy projects that have been held up because governments did not adequately consult with their indigenous communities. And these people have reacted with violence which many times leads to the death of lots of people. Let me just point out, just want to, if we show, this is actually a picture of an incident that took place in Peru in 2009, Bagua, when the government at the time, Alan Garcia, actually approved a whole series of investment projects in the Amazon region, and it resulted in the indigenous communities there having what turned out to be an uprising. 34 people got killed. Most of them, interestingly enough, were not indigenous people. They were Peruvian police. But in any event, these are the types of things that occur even today throughout most of Latin America, and it's because of this failure of governments to adequately consult with their indigenous communities. All right, now let me get out of this screen and just quickly wrap up by pointing out that even though, as I mentioned before, these are obligations incumbent on the governments who have either ratified ILO 169 or have accepted free, fair, and informed consent in their domestic law. How this has now moved on to become an obligation for private sector firms. Part of it has to do with the fact that there are a number of documents that have come out of the United Nations, for example, the United Nations Guiding Principles on Business and Human Rights in 2011. And from that came the UN Global Compact's Business Reference Guide on the United Nations Declaration of the Rights of Indigenous Peoples. These documents are now extending this obligation to private sector firms. For example, the UN Global Compact's Business Reference Guide on the UNDRIP says that if free, prior, and informed consent for a business activity that may impact indigenous land, territory, or resources is not granted, the activity should not proceed. What the compact is basically telling companies, indigenous peoples have a veto or should have a veto right ultimately. You also find in the OECD guidelines for multinational enterprises, which came out in 2011, it talks directly about respecting the rights of marginalized peoples. But in 2018, it was followed up with due diligence guidelines for responsive business contact. And they have a section specifically on consultation with indigenous peoples. The first thing they emphasize is consultation with indigenous peoples is a recognized human right in and of itself. Okay, this is something actually that comes out of some of these court decisions that have come out, for example, from the Court of Inter-American Human Rights in San Jose, Costa Rica. But what is interesting is these due diligence guidelines also say that if businesses choose to operate in countries that themselves don't enforce their human rights obligations, including the right to consultation with indigenous peoples, the company cannot use that as an excuse if consultation did not take place. So what this is telling is the companies, you have to do it. If the government doesn't fulfill its obligation to consultation with indigenous peoples, you have to do it. Now, there's a very practical thing that's going on in addition to these exhortations that are coming from the UN and from the OECD. You also have the multilateral banks like the Asian Development Bank, the Inter-American Development Bank, the IFC, which is part of the World Bank, are all now obligated to not only ensure that they comply with this this obligation to consultation, but anyone who borrows money from them, who takes a loan from them, is now also required to do the same thing. Okay. Now, as I said, there's also one very important practical reason for companies also to ensure that they consult with indigenous communities, regardless of what the governments may or may not decide to do. And that is the bottom line. Because we now have instances in Latin America where companies have invested millions of dollars for a mining project, for example, in the Andes, and that project has been halted for years. Or we have other instances in more recent years in which governments gave a concession, supposedly because they had already gone through the process of consultation. They gave a concession to a mining company, but because the indigenous community felt they were not adequately consulted with, and have either blockaded roads, have damaged equipment, have actually entered the premises and taken over, the governments have actually withdrawn their concessions after these companies invested millions and millions of dollars. So there's a practical bottom line impact as well that's causing these companies to take this right to consultation seriously. And the last thing I want to say is the other factor that's playing an increasingly important role is ESG. Because now these companies have to respond to their shareholders who are demanding that they comply with human rights obligations. And one of those human rights obligations is consultation with adequate and effective consultation with indigenous communities who may be detrimentally impacted by a investment project these companies are involved in. Okay, so with that, let me just quickly conclude. Thank you.
Thank you, Tom, and thank you to all the panelists for their fantastic presentations. We have now a few minutes for questions from the floor. I have a couple of questions, but I want to open the floor first. Okay, given that, I mean, if there are any questions from the floor, I will ask them. So please write them in the chat. Otherwise, I will go ahead with one of my answers, well, one of my questions. And if you could answer briefly, that would be fantastic. So all of you at one point or another made references to the fact that there is an ineffective enforcement of legislation. And in fact, Tom, you made very clear references to the fact that the lack of environmental consultation could potentially lead to conflict or the exacerbating violence and conflict in a given jurisdiction. So my question is, what can lawyers do in order to ensure that we support those communities that are facing such severe environmental situations? Can I start with maybe Sophia?
Yes, thank you very much, because well, first of all, thank you very much for the invitation, because all the approach that were given today were fantastic. I learned a lot. Thank you very much. I go away from this seminar with more questions and more willing to research, and that is fantastic. Well, as you said, there is a lack of enforcement. It's obvious, we all knew that. And what can we do? What can lawyers do beside the factor of redefine everything? Because we have the same problems for centuries, and the recognition of the rights for decades, and nothing is getting to the correct answer. So from my specific perspective, that is the constitutional jurisdiction, the role of the courts, what I think after analyzing the experience in several countries is that the problem of the remedies is that the remedies, they don't pursue the actual causes of the violation of the rights. They try to give small solutions addressing one cause isolated, but they don't address the structural causes of the violation that sometimes and many times are also related to stereotypical discrimination, structural discrimination in society. I mean, cultural discrimination. Why is this so difficult to understand that we have to approach the system with the perspective of the communities? The idea that Danielle gave us about the cultural translator, not only language translator, but in order to understand the culture, because how is possible to give them an adequate participation if we don't understand what do they mean, or we all mean about participation? So that demands to readapt our culture and to really think about how we are projecting our stereotypical discrimination even in the cases. There is a case regarding women's rights, Fernandez, a recent decision 2020-2021, where the Inter-American Court of Human Rights adopt the standard of the Inter-American Commission of Human Rights, where it says when the judicial power doesn't protect, it is part of the problem. It is part of the violation. So we have to, as from the judiciary, we have to think why we cannot approach to all the causes of the violation, and sometimes it's because the causes of the violation is in our own culture, and we have to avoid be part of the problem. So we have to create, according to Article 2 and to Article 25, remedies that are effective. If they are not in the law, we have to create them. And this is called control of unconventionality through omission, but we have to create it. Brazil has a lot of experience on that. There is no way the judicial power does not recognize his own fault in that. Well, thank you very much.
Thank you, Sophia. Julian, hand over to you. What can lawyers do?
Many things. At the local level, obviously, a lot of the forest defenders, including journalists, they need protection, they need help from the law. Often, it's not just about the powers that be roughing them up. Sometimes they try and use the law to intimidate, especially journalism. Yeah, I mean, they threaten them with defamation suits, these kinds of things. It's really important that lawyers are there to help these people who are often, criminalized by the governments. That's at sort of more local level. Also to be able to mount legal challenges to the government's systems, to understand their land policy use, to get access to their maps and their diagrams, and to, where possible, make civil claims when they're not upholding the law and letting logging take place in areas where there shouldn't be any logging, for example. So, we've seen examples we've looked at many times that the government has laws in place, it ignores its own laws blatantly. So if there's any way for lawyers to track that and to challenge that, then that would be a wonderful thing to do.
Fantastic. Well, this is a challenge for many of the lawyers present here today. I am sure that there are going to be a lot of positive reactions to your proposal for action. Thank you, Julian. Danielle, what about you? What are your thoughts?
Well, first of all, again, thank you for this great panel, and thank you for all the my co-panelists, and I subscribe Sophia's and Julian words, because I think that it's this challenge of diversity that we have, and we need to, as lawyers, if we're working on environmental law in specific, because it is tied to the communities on the territories. So we need to have a new open perspective to our profession, because their limits are not only in the use of languages, talking about indigenous languages, but even sometimes professional languages. We lawyers love to have our own jargon, and sometimes it becomes hard to. I remember some meetings with a development project on the field that were talking between engineers, lawyers, and indigenous people. There were 3 different languages, a lot of different languages going on, and sometimes that challenges give us the opportunity to open our minds and to learn beyond our own professional structure. And I think that this concept of rebuilding and rethinking and to permanently be learning and deconstructing ourselves is important. Not only deconstructing for structural discrimination, for example, but also for gender biases, and to be able to also to open to new technologies, to how to work with youth. So I think that we are in a very great position as lawyers to be flexible and more open to address and to approach these thematics. Thank you.
Thank you, Daniel. And that is certainly a big challenge for all lawyers, making the law and the legal profession accessible as possible. Thomas, over to you.
Well, I think it's important to understand that the UN guiding principles on business and human rights also include law firms. Law firms are deemed to be a business. So these obligations are incumbent not just on a company, it's also incumbent on law firms. The other thing too is that the role that in-house counsel can play. The reality is, if you're in a company, if you represent a mining company, if you represent an energy company, a renewable energy company, you better well damn know what the company's obligations are in terms of consultation. As I said, there are cases now coming out, and among other, the Inter-American Court of Human Rights, in which the right to consultation is recognized as an international human right, and it's incumbent on the companies as well. If you don't advise the company correctly, you're going to get hit with a malpractice suit. If you're a law firm and if you're in-house counsel, you probably were going to get fired. So I think that's a very strong incentive for lawyers to brush up on what their obligations are. And I think there's also another thing that's very important. A lot of this stuff that's coming, for example, the UN Guiding Principles on Business Human Rights, it's soft law. But a lot of countries are incorporating this into their domestic law. They're making it an obligation. France, for example, in 2017, basically now requires any company that has a substantial presence in France, which could be a foreign company, a US company, for example, but if it has a substantial presence in France, it is required to ensure that human rights are being respected by the company, but any of its subsidiaries outside of France as well, too. If you don't, the French courts are there for victims to actually bring a lawsuit for monetary restitution in France. So you know, a lot of this soft law obligations on businesses is now being converted into hard law, depending on the country.
Thank you, Tom. And on that note, I think that's it from us. We are over time. But I want to give a big thanks to all the panelists, to our keynote speaker, Gabriela Ramos. And on that note, I hand over to you to give the closing remarks, Lourdes. Thank you.
Thank you, Lisette. Given the time, I guess that would be very brief, but we had really a wonderful, and very, complete presentation. So I thank our panelists, the attendees also. And just to remark the importance of the topics that, Sophia mentioned in terms of discrimination and structural discrimination, and that the solution is not just through the judicial systems, but they need to be prepared when they need to act, as she mentioned. But there are a lot of solutions that could be prejudicial or parajudicial that can be addressed with the legal framework. But it's not only as, the legal framework, but also the enforcement, because we can create the most beautiful legal framework. If enforcement is not on the menu, it really is doomed to fail, isn't it? So that's a very important aspect. And that's where lawyers, in whichever dimension of practice they are, can do a lot. Another thing that I like a lot, because I believe deeply in that, is what Danielle said in terms of the issue of rule of law, not just for lawyers, isn't it? Everyone needs to learn about the premises and fundamentals of rule of law, because it's basically their rights and the quality of life that they live that is going to be impacted by that. And so then that's an important aspect too. And I appreciate also what Julian and Thomas talk about, and maybe be aware that all these environmental crimes are more often than not related to other, serious international crimes, forced labor, and, trafficking in human beings for purposes for labor and others. So it all is interrelated. So this comes to say, it is really a holistic approach. It's not just as concept ESG, it's try to get through all, not only the environmental, but the social and governance issues of that. And the bottom line is the solution, the problem is not just legal. So the solution cannot be just legal. So we lawyers need to sort of learn the language of the other disciplines that are related to this and speak that language and develop a culture of compliance and learning and raising awareness. Because as Thomas also mentioned, it's like we have to be inclusive. We have to do consultation, and not only because it's the right thing to do, but it's also because it's a smart thing to do if you want sustainable business and not, a business project that has to budget up a lot of risk management because you didn't do the right thing or maybe will fail. But that's kind of something that I just wanted to say. But thank you very much to all again. And we leave you not without inviting you to the next sessions of the webathon. We have really a good, set of programs for the rest of the week. This was the second of 9. So tomorrow we are going to continue with a program on surveillance, spyware, and another one on times of armed conflict. And then we'll have other programs for Wednesday and Thursday that you can find on the web, and closing on Friday with a showcase program on defending democracy, human rights, and the rule of law. Without that, thank you, Lisette, again, for all your invaluable help, and to all our panelists and attendees. Thank you.